Chapter 40. Receiving Stolen Goods. Section 640. Definition and Essentials. The crime of receiving stolen goods is the act of taking into one's possession, animo furandi, personal property of another with actual or constructive knowledge that it is stolen property. It is essential not only that the property has been stolen, but also that it possess the character of stolen property at the time it is received into the possession of the accused. He must have actual or constructive knowledge when he acquires possession of it that it is stolen property, and must receive it animo furandi and with the consent of the other party. Section 641. A statutory offence. At common law, receiving stolen goods is probably not even a substantive misdemeanor. In 1691 a statute was passed in England which provided that if any person or persons shall buy or receive any goods or chattel that shall be feloniously taken or stolen from any other person, knowing the same to be stolen, he or they shall be taken and deemed an accessory or accessories to such felony after the fact, and shall incur the same punishment as an accessory or accessories to the felony after the felony committed. In 1827 another statute was passed which provided that if any person shall receive any chattel, money, valuable security or other property whatsoever, the stealing or taking whereof will amount to a felony either at common law, or by virtue of this act, such person knowing the same to have been feloniously stolen or taken, every such a receiver shall be guilty of felony, and may be indicted and convicted as an accessory after the fact, or for a substantive felony. It will be observed that under the former of these statutes the offence was only an accessorial crime, whereas under the latter it was also a substantive crime. Hence under the former statute it was essential that the property be received from the thief, while under the latter it was not. In this country, statutes have been enacted in probably all the states making the offence a substantive crime. Under these statutes it is not essential that the property be received from the thief. The contrary, however, has been held, but this view is not correct upon principle, nor in harmony with the great weight of authority. Some statutes make it a crime to receive goods animo furandi which have been embezzled or obtained by false pretenses. These statutes are separate and distinct from those which make it a crime to receive stolen goods. It has been held that one who participates in the larceny may not be convicted also of the offence of receiving stolen goods. On the other hand, however, it has been held that a verdict for receiving stolen goods will not be set aside because the evidence would have justified a verdict for the separate offence of larceny. Section 642. The act must be felonious. The act of receiving the property must be felonious. It is essential, therefore, that the thing received be stolen property. This attribute must exist at the time the property is received. Thus, where the defendant was convicted of receiving stolen goods, and the proof showed that they had been found in the pockets of the thief by the owner, that with the view of catching the receiver of such goods, brass castings, the owner returned them to the thief and directed him to sell them to the defendant, which was accordingly done, the conviction was set aside because the goods, when received by the defendant, had ceased to be stolen property, and were sold to the defendant with the consent of the owner. Again, in another case, the defendant was convicted of receiving a parcel of postage stamps, of the value of $150 which had been stolen. The proof showed that the stamps were stolen at Unionville, Mo., and sent by the thief, by express, to Milwaukee, Wis., addressed to the defendant, that the thief was arrested at Quincy, Ill., and that he gave an order to the postmaster there on the express agent at Milwaukee by which that postmaster acquired possession of the parcel, that the United States authorities ordered the postmaster to enclose them in the same wrapper and forward them as first directed, that this order was carried out and that the parcel was received at Milwaukee by the defendant. On appeal, the conviction was set aside and a new trial granted on the ground that the stamps when received by the defendant had lost their character as stolen property. The ownership of these stamps was in the United States. The Quincy postmaster was the agent of the owner. When Crawford, the thief, surrendered them to this agent, they were reclaimed property that had been stolen, but their character as stolen property ceased in the hands of the postmaster, so far as the subsequent receiver was concerned. The moral turpitude of a receiver under such circumstances may be as great as in case the property comes directly from the hands of the thief, because the criminal intent on his part exists equally in both cases. But to create the offense which the law punishes, the property when received, must, in fact, and in a legal sense, be stolen property. If these stamps were received by the defendant, they did not, when received, upon the proof made, bear this character. They had been captured from the thief by the owner, and the act of forwarding them to the alleged receiver was the act of the owner. Section 643. Consent of the other party essential. Possession of the property must be obtained with the consent of the party from whom it is received. If acquired by trespass, the offense is larceny. Section 644. Guilty knowledge of the recipient. It is also essential that the recipient possess guilty knowledge as to the character of the property, and this guilty knowledge must exist at the time he receives it. It can be constructive, however, as well as actual, and, it has been held, may be implied from the receipt of goods under circumstances sufficient to satisfy a man of ordinary intelligence and caution that they were stolen. Other jurisdictions hold that knowledge must be actual. But if one after obtaining knowledge undertakes to deprive the owner of the rightful use of the property, he may be convicted of receiving stolen goods. And a lawyer who aided the thieves who had stolen securities in getting a reward for their return and had the securities in his possession while the reward was being paid, was convicted of receiving stolen goods. Section 645. Doctrine of lucri causa. As in the case of larceny, the doctrine of lucri causa is not applicable, as a rule, to the crime of receiving stolen goods. It is not essential that the recipient gain any benefit therefrom, or expect to do so. It is sufficient if he aids the thief to conceal the property. Guilty knowledge that the goods were stolen has been held sufficient. But where a statute expressly provides that the property must be received for gain of the recipient, the foregoing rule does not apply. Section 646. Manual possession not essential. It is not essential that the accused have manual possession of the stolen property. In one of the cases the defendant was convicted of knowingly receiving a stolen watch. His contention was that there was no proof that he had possession of it. The judge instructed the jury that if the defendant knew that the watch was stolen, that H had it, that the defendant could make him deliver it, and had absolute control over him, they would be justified in finding him guilty. On appeal, the conviction was affirmed. Again, where C stole goods and took them to the defendant's store, and the defendant ordered her servant to take them to a pawn shop and bring back the money received for them and give it to C, which order was carried out, the conviction, on appeal, was sustained, since it was virtually as much a receiving of stolen goods by the defendant as if her own hand, and not that of her servant, had received them. It is enough to aid in the concealment of the goods, knowing them to be stolen. Section 647. Subsequent adoption of Wife's Act. Where the thief leaves the stolen goods with the wife of the accused, and she pays him part of the price, and her husband subsequently meets him, agrees on the price and pays him the balance, the husband is guilty of receiving stolen goods. The act of receiving the goods is incomplete until the husband meets the thief and they agree to the terms. Section 648. Depriving the owner permanently of possession. The term permanently, in its application to the crime of receiving stolen goods, has the same restricted meaning that it has in its application to the crime of larceny, where the defendant was convicted of receiving stolen goods, and he contended that the conviction should be quashed because the proof showed that he did not intend to deprive the owner of the property of his ownership in it, that he intended to return it upon receiving a reward for so doing. The court held that if the jury believed from the evidence, as they well might, that the defendant concealed from the owner the fact that he had the property, intending to defraud him into paying a reward for it, the crime was established. Section 649. Recent possession of stolen goods. The recent possession of stolen goods, unexplained, is a circumstance from which the jury may infer the possessor's guilt. But it does not raise a presumption of guilt as a matter of law.